Craig versus Kristine Bunch, 24 CYCV 11062. I'll note for the record that we have petitioner present once again with counsel, respondent also present with counsel. All parties previously stated ready to proceed. I assume that's still accurate. Petitioner.
Yes, Your Honor.
Respondent ready to proceed. I assume so.
Yes, Judge.
Ms. Del Percio's.
She's distracting me, Judge.
I know. All right. Any preliminary matters that we need to take up?
Your Honor, I have some exhibits. If I could approach, I'll put one on your bench and hand them over.
Sure. Sure. Respondent, any preliminary matters that we need to take up?
No, Judge, thank you.
All right. That being the case, petitioner, when you're ready, you may call your first.
And Your Honor, I have two exhibits to admit as self-authenticating prior to calling Mr. Craig.
Which ones are those?
Exhibits 1 and 2 in the notebook I've handed you.
Exhibit what?
Exhibits 1 and 2.
Oh, 1 and 2. That is the petition and the, well.
Your Honor, Exhibit 1 is a prior full order of protection that was previously issued against Ms. Bunch. It's a self-authenticating order of the Clay County Court, and pursuant to 455.040.4, prior sub E, prior protection orders against respondent are relevant factors for the court's consideration. We move for the admission of Exhibit 1.
Any objection to Exhibit 1?
Well, Judge, I think I think the court can take judicial notice of it. It is what appears to be a file stamp copy dated January 29th of 2013 that was filed by Mr. Callahan against Ms. Bunch, so I don't know if that's evidence. But I object to that, Judge, to be admitted, but I don't have an objection to it being the court taking judicial notice of that. With respect to Exhibit number 2, it appears to be a petition for defamation filed by Mr. Kreese against Ms. Bunch. So I don't know how that's relevant to these proceedings, so I object for relevance on that issue.
Exhibit number 1 will be admitted over the objection. Exhibit number 2, as far as relevance, counsel, what's the relevance?
Your Honor, again, under 455.040.4, sub C, irrelevant factors, respondent's history of stalking, and the petition for defamation lists allegations that I think under 455 would constitute stalking and are going to be factually similar to the allegations we're going to talk about here today. And it's notable that while that petition was dismissed voluntarily, as noted in the exhibit, it was only done so because of Ms. Bunch's Chapter 13 bankruptcy, and that just recently Ms. Bunch, in fact, filed a counterclaim in that case against this real estate developer for $5 million. And once again, I think that conduct as against real estate developers is going to be relevant to and provide context for what's happening in this case specifically, and additionally that under 455.010.15, the court's going to have to evaluate whether Mr. Craig's concerns are reasonable in his situation. And then this exhibit is part of the evidence about what his situation consists of and where his concerns would come from.
Response.
So, Judge, I've pulled a case that was just issued by the Eastern District September 10th of this year. It's ALO v. GLN. It's ED 112141. And when it comes to, in that case, Judge, there was a woman who had concerns over intimate photos being linked on social media. There was allegedly threat posts about things like that, and the court there said that the act is intended to prevent potential violence, not hurt feelings or harm to reputation. And in that case, the court found that the threat would not cause a reasonable person fear physical harm. Judge, this case, these people have never been married. They're not related by blood or marriage. They've never been adult household roommates. They've never been involved romantically. For the petitioner to argue that a dismissed petition for defamation should be used to show how he feels, defamation relates to his defamed character, Judge. So by virtue of this case, I don't believe that's relevant. And I'd like to renew my objection to Exhibit Number 1. Judge, that case has nothing to do with these parties. That was filed by Michael Dean Callahan against my client over 10 years ago. Now the petitioner in this case wants to use that against my client. So I object to those two exhibits again, Judge, being admitted as evidence.
So the renewed objection number 1 is still overruled because under 454.040, it does say that the prior full orders issued against the respondent. As far as number 2, the objection sustained. It's to relevance. Additionally, it's not a judgment. It's these are allegations, a petition. And I think as far as subsection C, it talks about the stalking regarding the petitioner. And I think that petitioner in this case isn't even a named party, and it's not a judgment. So 2, the objection sustained. 2 is not admitted. All right.
May I recall Mr. Craig to the stand?
All right, sir, if you'll make your way up to the witness stand, raise your right hand once you get up there. We will have you sworn in.
Just line this up. When you get up there, remain standing, raise your right hand.
Do you solemnly swear the testimony you are to give today to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you can please state and spell your name for the record.
Eric Craig, Erickraig.
Thank you.
All right, you may proceed.
Could you please state your name for the record?
Eric Craig.
Mr. Craig, please briefly describe your business.
I'm a real estate business owner and developer.
How was it that you first came to learn of the respondent here, Ms. Bunch?
She's contacted me in the past in regards to purchasing, leasing properties. That's how I came to know her.
At some point, did Ms. Bunch's communications to or about you become adversarial?
Yes, sir. There were several instances where Mrs. Bunch would post negative things in regards to me, negative context in regards to me on social media. She also did weekly protest out in front of my office for about a 2-month period. And then the concern came about when I would be various places within town and she'd be taking pictures of me. And that's when I felt that the stalking started commencing.
Well, let's take that chronologically. Describe the protests that you just testified to.
I was taking a project through the city for a TIF approval, and the protesting outside of my office began at that point in time.
What did that consist of?
3 to 4 people with signs, social media posts, a lot of accusations.
Was Ms. Bunch one of those persons?
Yes, sir.
Look at Exhibit 3 in your notebook.
Sorry. Okay.
You had testified about social media posts from Ms. Bunch. Is Exhibit 3 an example of one of those posts?
Yes, sir.
And in the first paragraph of this exhibit, is your name specifically listed here?
Objection, Judge, in testifying about an exhibit that's not admitted to evidence, there's been no foundation laid, and I believe it's hearsay.
Sustained.
Did you ever see this Exhibit 3 as posted on social media?
Yes, it was sent to me.
Who sent it to you?
A coworker.
And did you identify who made the post?
Yes, sir.
Who was that?
Kristine Bunch.
I don't know if he can even identify who made the post. You know, he doesn't know when it was posted. Again, it's a document that's not been admitted to evidence.
Overruled as it relates to establishing foundation. So you can continue.
To the best of your knowledge, who made this social media post?
Objection calls for speculation, Judge.
Overruled.
Kristine Bunch.
And without talking about the rest of the content of this exhibit, did your name appear in this post?
Yes, sir.
Your Honor, I move for the admission of Exhibit 3.
Any objection?
Foundation, Judge, here, sir.
What's missing on foundation?
Well, we don't know when it was posted or really who even posted it. He says it was Kristine Bunch, but I don't know how he can show that. And also relevance, Judge, this is a petition for order protection. There's been no, again, these people weren't related by blood or marriage or romantically involved. There's no allegation within this document that indicates that he was threatened by my client. So for all those reasons, Judge, we object.
Objection to relevance is overruled. Response as far as foundation.
Well, Your Honor, again, this is, if the foundation, I think, has been laid insofar as this is a document that he's listed in, that the witness is listed in, that the witness has seen, and that when it comes to social media, that's how any of us experience it, is a statement by a party opponent. If Ms. Bunch would like to take the stand so that the court consider the weight of the evidence, and if she would like to go under oath and say, this isn't my post, I never wrote this, then the court could weigh that and the credibility of the witnesses with respect to that. But as to admissibility, I think it falls under a hearsay exception, and we've laid adequate foundation.
Well, I think you're right that it could fall under a hearsay exception, but I think what's missing is a foundation as far as that it was a statement by the respondent. So for now, objection as a foundation is sustained.
Did you have any other experiences with Ms. Bunch or anyone else that led you to believe that this post we're looking at, Exhibit 3, was actually made by her?
Objection with respect to the form of the question, Judge. I don't know what, and also relevance as to what anybody else would tell him. I think there's also hearsay, so multiple objections.
Overruled. You can answer.
Yes, I believe that Mrs. Bunch made this post.
What led you to believe that?
She has 2 active pages on social media that she's very active on posting on, and I believe that she is the one behind posting these. It has her name on it. It is elect Kristine Bunch, Ward 1. She also operates a page called Smithville News.
And how do you know that she operates this page or that page?
I'm on social media. I personally have seen it myself, but I tend to have unfollowed her because I don't want to read what she has to say. But things are sent to me.
Your Honor, I move for the admission of Exhibit 3.
Any objection?
Objection, foundation, Judge, and hearsay.
Objections overruled. 3's admitted.
Turn to Exhibit 4. You had testified earlier about one of the 2 pages that, to the best of your knowledge, Ms. Bunch operates on social media, and one of them is known as Elect Kristine Bunch for Ward 1 Alderman. Is that accurate?
Yes, sir.
And is Exhibit 4 a post made on that page?
Yes, sir.
And on the bottom, does this post include a photograph of a letter sent to Ms. Bunch?
Yes, sir.
There's a does your name appear in this post, Exhibit 4?
Yes, sir, specifically.
What is Pulse Development?
It is a development company that I have an association with.
And does Pulse Development appear in this post?
Yes, sir.
And do you see the phone number on Exhibit 4?
Yes, sir.
Judge, I'm going to object to him testifying to the document that's not admitted to evidence.
Response.
I'm trying to lay that foundation now. I'm not trying to ask what the content in a narrative capacity is, but to the extent, again, he's referenced here his business, the phone number of his business. that's going to go towards laying my foundation and the relevance of the exhibit itself.
Overruled. You answer.
Does Pulse Development have a telephone number?
Yes, sir.
Does that telephone number appear in Exhibit 4?
Yes, sir.
How did you, have you ever seen Exhibit 4 before?
Yes, I have.
And how did you first see this post?
On social media.
Your Honor, I move for the admission of Exhibit 4.
Objection, foundation. We don't know when it was posted. We don't know when it was made. We don't know who it was made by.
Objection is sustained.
As to foundation, Your Honor?
Foundation.
Okay. Did Ms. Bunch ever call? Do you know if Ms. Bunch ever called you at Pulse Development?
Not me, no, but she did call Pulse, yes.
Objection to Randy Rose's statement. If she never called him, then anything that he would say about calling Pulse Development would be hearsay. Judge.
Sustained.
Did Ms. Bunch ever communicate to you criticisms that there was no bank backing Pulse Development's developments?
Not to me specifically, but on social media, yes.
Objection, Your Honor. Hearsay.
Sustained.
At some point, did you ask an attorney on your behalf to send a cease and desist letter to Ms. Bunch?
Yes.
What prompted you to make that request?
After many derogative posts, comments, public statements, I contacted my attorney to seek legal counsel on what we should do, or what I should do.
What was the nature of these negative comments that you received?
At this point in time, it was a defamation of my character.
Could you give us some examples?
She made comments that I have been involved in lawsuits, which are false. She says I was involved in lawsuits against other real estate agents, which is false. She said that I have not filed my taxes, which is false. Things like that of that nature.
Could you turn to Exhibit 6? Have you seen Exhibit 6 before?
Yes.
Is Exhibit 6 the cease and desist letter that your attorney sent to Ms. Bunch?
Yes.
Did you see this letter in draft form before your attorney sent it?
Yes.
Did you approve it?
Yes.
Your Honor, move for the admission of Exhibit 6.
Any objection to Exhibit 6?
Well, relevance, Judge. I don't think sending a cease and desist letter by its nature creates a presumption that there's some harassment or stalking going on, and also foundation and hearsay, Judge.
6 is admitted over the objection.
Did Ms. Bunch's conduct improve from your perspective after the exhibit letter in Exhibit 6 was sent?
No, sir. It got worse.
And by reference, that letter was dated May the 24th of 2023. Is that right?
Yes, sir.
Could you turn to Exhibit 7? And is Exhibit 7 a post from the same social media page that some of our prior exhibits have been, entitled Elect Kristine Bunch for Ward 1?
Objection to the defendant testifying to an exhibit not in evidence, Judge.
Overruled.
Yes.
And what is, in Exhibit 7, at the bottom there's a photograph. Is that photo identical to the Exhibit 6 letter that you had your attorney send to Ms. Bunch?
Objection,
Yes.
Judge. Again, there's not adequate foundation that has been laid for the respondent to testify to this exhibit. It also contains hearsay.
Sustained. Foundation.
You ever seen Exhibit 7 before?
Yes.
How did you see it?
On social media.
And does it contain your name
Yes.
in multiple places?
Yes.
And does it contain the name of your attorney? Well, is Andrew Launard one of your attorneys?
Yes, sir.
Is he the attorney you asked to write the cease and desist letter to Ms. Bunch?
Yes, sir.
Does his name appear in this post?
Yes, sir.
Does a photo of that letter appear in this post?
Yes, sir.
Your Honor, I move the admission of Exhibit 7.
Objection, foundation.
Sustained. Foundation.
Earlier, you testified that after your attorney sent the letter, Exhibit 6, that Ms. Bunch's conduct got worse from your perspective. How so?
Her comments on social media and publicly were a lot more frequent.
Did the increased frequency of her comments lead you to ask your attorney to send her a second letter?
Yes, sir.
And could you turn to Exhibit 8? You previously testified Mr. Launard as one of your attorneys, is that right?
Yes, sir.
Have you seen Exhibit 8 before?
Yes.
Is Exhibit 8 a letter that Mr. Launard drafted at your behest?
Yes.
Did you see it in a draft form before it was sent out?
Yes.
Is Exhibit 8 a complete and accurate copy of the draft you saw?
Yes.
And was this a letter sent that you asked your attorneys to send to Ms. Bunch?
Yes.
Your Honor, I move the admission of Exhibit 8.
Objection, foundation, and hearsay, Judge. This was not created by the petitioner. It's signed by a lawyer who's not present today. I cannot cross-examine this witness, the individual who created this document. So for those reasons, I'm objecting.
Certainly all that will go to the weight, but 8 is admitted over the objection.
And if you turn to the second page of Exhibit 8, you see a certified mail receipt. You see that?
Yes.
After Ms. Bunch received the letter that's Exhibit 8, which is dated January the 5th of 2024, did her conduct, from your perspective, improve?
No, it got worse.
How so?
Her posts were very personal, and I felt I was being personally attacked.
What about those posts made you feel like you were being personally attacked?
Making posts in regards to what I do for a living, my business as a whole, my profession as a whole.
Did Ms. Bunch ever compare you to or accuse you of being a domestic abuser?
Yes.
Could you turn to Exhibit 9? Have you ever seen Exhibit 9 before?
Yes.
What is it?
It's a post that she made following the next page. This was very concerning to me because she equivalates.
Objection to the defendant.
Sustained.
Response.
Sustained.
I'm sorry.
That's okay. Just tell me what it is, not what it says.
A post that Kristine Bunch made.
And it's listed here as Smithville News. And you testified earlier that it's your understanding that is a site that Ms. Bunch operates. What leads you to believe that?
Objection to the form of the question. counsel's testify what's in the document. I've already objected to that, so I object to foundation, Judge.
Overruled. You're just asking why he believes that. But go ahead and you can answer.
Could you ask me the question again, please?
Sure. What makes you believe that Ms. Bunch runs the social media site Smithville News?
Because she shares it off of her personal page and also her Kristine Bunch for alderman. So she cross-shares those posts.
Are you referenced in Exhibit 9?
Yes.
And do you know if Ms. Bunch has filed a complaint against you with the Missouri Real Estate Commission?
Yes, she did.
In 2024, has anyone else filed a complaint against you with the Missouri Real Estate Commission?
Objection, relevance, hearsay, calls for speculation.
Overruled. You can answer.
No.
Does this post refer to, in Exhibit 9, my recent Missouri Real Estate Commission complaint where I found Eric Craig real estate team not properly licensed?
Correct.
And is that language one of the things that led you to believe that Ms. Bunch wrote this post?
Yes.
Your Honor, I move for the admission of Exhibit 9.
Objection, foundation, Your Honor.
Sustain. Foundation.
You testified earlier that Ms. Bunch accused you of being or compared you to a domestic abuser. How so? How'd you do that?
In a post that she made, she gave an example of that and said my name.
Was there a point in time in which Ms. Bunch's conduct went from being a political or business dispute to being an issue of your personal safety?
Yes.
What conduct of hers that you observed moved the situation in your mind from one category to the other?
At first, it was just social media posts, her taking pictures of me in various places, to her pulling up in front of my office with 2 German Shepherd dogs, rolled the windows down. Dogs were aggressively barking at me. She is videoing this with her phone and laughing. And at that point in time, I went to the chief of police in Smithville.
Let's unpack some of that bit by bit. You talked about a moment ago Ms. Bunch taking photos of you in public. How do you know she was doing that?
I saw her
And when did you see her taking photos of you?
frequently.
At during what months of the year, or what time span did this occur?
At least a year
This past year, 2024.
and prior.
How many times did you observe Ms. Bunch taking photos of you in public?
So often that I lost count.
Were any of these occasions an occasion in which you and Ms. Bunch, you had invited Ms. Bunch to be in your presence?
No.
Were any of these occasions in which you and Ms. Bunch both had reason to be in the same place at the same time?
No.
To the best of your knowledge, was Ms. Bunch only there for the purpose of taking photos of you?
Yes.
Did Ms. Bunch later post those photos on social media?
Yes.
Were you alarmed by the conduct of her taking photos of you?
Yes.
Give us examples of some of the places you were when you saw Ms. Bunch taking photos of you.
Out in front of my office, in the back of my office, out in front of a coffee shop, at a grocery store.
So this was a sequence of events happen more than once? Is that
Yes.
right? And did her repeatedly taking photos of you in public cause you fear of danger of physical harm?
No.
You referenced another incident with her dogs. Where did that take place?
Out in front of my office.
And when did it occur?
I want to say it was February 10th, somewhere around there.
Of 2024?
No, I'm sorry, October 10th. I'm sorry.
October 10th, about October 10th
Yes.
of 2024?
Yes.
And about what time of day was it?
Noon.
And what were you doing at that time?
I was on a business call out in front of my office, outside walking.
That day, had you invited Ms. Bunch to come to your business?
No.
Did you have an appointment with her?
No.
From your perspective, did she have some other purpose for happening to be in front of your business at that time, or was she there to see you?
I think I believe I saw her when I was out front.
Judge, it's also speculation, Judge. I'm not answering what she was doing there at a particular time, if she had purpose to be there or not. I don't know how you know that.
Sustained as it's speculation.
Describe what you saw her doing that day.
She saw me out in front of my office, and she stopped her vehicle, rolled her windows down, and her dogs began to aggressively be barking. And then she was videoing or taking pictures of me at the same time.
Was she trying to restrain the animals in any way?
No, she was laughing.
Did you later see social media posts about that event?
Yes.
And what did you see in those social media posts about this event?
What's on Exhibit 10 was a reel that she posted of her dog aggressively barking.
Was there any sort of caption?
Uh,
She later posted that her dogs are a very good judge of character.
Hearsay Judge Foundation, there's no document here.
There is.
Show what she posted later, so I object for those reasons.
Sustained as to foundation.
I think you testified earlier, you've seen Ms. Bunch's dogs?
Yes.
You've seen what they look like when they're barking aggressively?
Yes.
Was Exhibit 10 a video clip of the dog you saw?
Yes.
The petitioner testifying to exhibit not in evidence.
Overruled.
That was the same dog you saw as the one that was in the video?
There was two. Yes.
And later you saw that video on the Kristine Bunch for Alderman social media page?
Yes.
And is Exhibit 10 a screenshot of that post?
Yes.
Objection, foundation, and hearsay, Judge.
Overruled.
Move to the admission of Exhibit 10.
Objection, foundation.
Sustained as a foundation.
Between Ms. Bunch taking photos of you in public and her bringing her dogs to your office that you've just described, did that sequence of events alarm you?
Yes.
Does it cause you to fear of physical harm?
Yes.
And what did you do in response to those events?
I met with the police department of the city of Smithville, specifically the Chief Lockridge.
And I don't want to know what Chief Lockridge told you, but after that meeting, did you take any further steps?
Yes, I filed this protection order and contacted my attorneys.
Prior to that, did you send any sort of message to Ms. Bunch?
No.
Did you ask Ms. Bunch not to be present on your property?
Yes.
How did you convey that?
Via text message.
And you sent a text message to Ms. Bunch?
Yes.
And what did it say?
I listed out properties that I own and gave her notice of no trespass on my properties.
And did she respond to you in any way from that message?
Yes.
What was her response?
I don't recall.
Was her response, did her response lead you to believe that she was going to comply with your request?
No.
Turn to Exhibit 11. Do you know what Exhibit 11 is?
Yes.
You ever seen it before?
Yes.
How did you first see it?
I saw it personally on Facebook.
And what is the title of the page that it was posted on?
It was in reference to my protection order.
And we'll get to that, but at the very top here, just which page was Exhibit 11 posted
Kristine Bunch for alderman.
on? And in this version, there's a icon of someone. Do you recognize the person in that picture?
Yes.
Who do you recognize that to be?
Kristine Bunch.
And is she sitting in this courtroom?
Yes.
Could you point her out for us? And let the record reflect the witnesses indicated the respondent. You testified a moment ago that Exhibit 11 was a response to your petition for protection. Why do you think that?
She references that she's not able to go to certain things because a boy got his panties all in a bunch.
And did you understand that to be a reference to you?
Yes.
Your Honor, I move for the omission of Exhibit 11.
Objection, foundation. And relevance.
Sustained foundation.
Could you turn to Exhibit 12? What is Exhibit 12?
The petition that I filed.
Did you fill out the form?
I did.
Did you sign it?
I did.
Did you sign it under oath?
Yes.
Are the statements in this form correct to the best of your knowledge?
Yes.
Did this petition result in an ex parte order of protection?
Yes.
Did you turn to Exhibit 13? To the extent necessary, Your Honor, I guess I move for the omission of Exhibit 12.
Any objection?
No objection.
12's admitted.
Is Exhibit 13 the ex parte order of protection?
Yes.
Your Honor, I move for the omission of 13.
Any objection?
Objection.
13's admitted.
And is this the order of protection that has been in place since you filed your petition?
Yes.
And are you here today asking the court to extend that order for another year?
Yes.
And are you here today to ask the court that extended order be automatically renewable?
Yes.
No further questions, Your Honor.
Any cross-exam?
Before I do so, Judge, I move for a dismissal of petitioner's petition. I don't believe that he's made a prima facie showing under the law that he has objectively he meets he's not satisfied the objective component of the stalking statute. There's no evidence of any physical encounters. There's no been evidence of no physical threats. Everything that he's alleged has just been damage to his reputation in online posts. Seeing my client out in front of his business on a public roadway in her vehicle, even though she does have dogs, she's laughing. There's no indication that an objective person would be fear for their lives in this situation. So none of the evidence presented meets that burden, Judge. For those reasons, we're requesting the court dismiss the petition.
Motion's denied. Cross-exam if you wish.
Now, sir, do you file a police report when you went to the police department?
No.
Why not?
I was told by the chief of police that I had to give her notice of no trespass.
You ever tried to file a police report against my client?
No.
Why not?
I didn't feel threatened until the dogs.
Okay, let's get to that dog situation. Your business, is there a four-way stop right out in front of your business?
No.
There's no stop sign in front of your business at all?
It's about 20 yards away.
And prior to that, you've been communicating with my client via text messages. Is that correct?
I sent one notice. Well, I sent one text via notice of no trespass.
How did you get her cell phone number?
It's on these documents that are in front of you.
Okay. Now, you said that she was protesting out in front of your property. Is that right?
Yes, sir.
And do you believe that she has a right to protest out in front of your property?
Yes, sir.
Okay. You said there were 3 or 4 other people that were out there as well. Is that correct?
Yes, sir.
Did you ever complain about them protesting in front of your property?
No, sir.
File order of protection against them?
No, sir.
Okay. You said that you're alarmed because she's taking pictures of you in public. Does taking pictures of you make you fear for your life and harm?
I find it very unusual, the consistency and the frequency of that.
Now, you made a lot of statements, and there's a lot of testimony about you seeing things online and her posting things, allegedly. Is there any particular reason why you just didn't stop looking at stuff online?
I did actually stop looking online
When did you stop that?
multiple times.
So you stopped multiple times. That means that you also started back up again multiple times, correct?
No, sir. Things were sent to me.
I have no further questions.
Redirect?
No, Your Honor.
All right, sir, you can step down. Anything further from petitioner?
No, Your Honor.
Just your arrest, respondent.
Your Honor, I call Kristine Bunch.
All right, ma'am, if you will please make your way up to the witness stand. Once you get up there, we'll have you sworn in.
Do you solemnly swear the testimony you're to give today to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Be seated. If you can please state and spell your name on the record.
Okay.
May it please the court, Your Honor?
You may proceed. Oh, after we state your name.
Oh, I'm sorry.
Kristine Shannon Bunch. Kristine. Shannon, Shannon, Bunch, Bunch.
You may. Now you may proceed when you're ready.
Please state your name again. I'm sorry.
Kristine Shannon Bunch.
You are the respondent in this cause of action. Is that right?
Yes.
And you know the respondent here. Is that correct?
Not personally, but know him.
Okay. You've heard his testimony about protesting out in front of his business. Is that right?
Correct.
Okay. And why were you protesting?
Hang on. It was in front of City Hall.
Okay. So,
His business was across the street. So we weren't in front of his business. We were at City Hall.
what were you protesting?
Objection to a tax increment financing plan that he was proposing to get from the city of Smithville.
And do you believe you have a legal constitutional right to do that?
He can ask, yes.
Do you believe that you had a constitutionally protected
Yes.
First Amendment right to protest?
Yes. And share my grievances with the government, yes.
Is that what you were doing?
Yes.
Okay. And you heard the petitioner's testimony about you taking pictures of him at his business around town. Did you do that?
I only took a picture on him.
One question at a time. Did you take pictures of him?
I took a picture, yes, while he was on his
Did
land.
you also video it?
I did video the land.
Okay. And do you believe that you have a First Amendment constitutional right to do this thing?
It was the land I was taking pictures of because,
That's my question.
oh,
Do you believe that you have a First Amendment constitutional right to video and photograph him?
Your Honor, I'm going to object to the relevance of her testimony about what she believes, and also the foundation. She's not a constitutional expert. The court can determine, but she's not allowed to opine about what isn't a constitutional right.
Overruled. She can answer.
yes.
Okay. Why did you take the picture of it?
Freedom of the press. I own Smithville News LLC with the state of Missouri, and for informational purposes, because our local town does not have a newspaper, I was educating the public on what was going on with the illegal asbestos removal, and he happened to be on the land. I wasn't actually videoing him, I was videoing the illegal asbestos removal, and he has 3 violations from Department of Natural Resources.
Your Honor, I'm going to object to that answer. Even beyond the scope of the question asked, move to strike it as also being lacking foundation and consisting of legal conclusions.
Sustained. The last part of the answer as far as the alleged violations will be stricken.
Did you ever post things on social media about the petitioner?
Yes, I actually posted the violations from DNR.
Did you ever threaten the petitioner?
No,
Did you ever threaten to hurt him?
no.
Did you, you heard the petitioner state that he's always paid his taxes, he's never been behind, is that right?
Yes, there's actually a document on my
I'm
desk.
just asking you, is that right?
It's right that I posted that, yes.
Okay.
Yes.
That hurts the witness, Judge.
You may.
I'm handing you what's in Martha's response. Is it one? You recognize this document, yes or no?
Yes.
What is it?
Eric Craig tax lien judgment,
Okay, from where?
Clay County,
And from when?
11/15/22, judgment entered Eric Craig,
Okay.
certificate of tax lien.
So, did you ever post that he didn't pay his taxes?
Yes,
And isn't it true that the president of court today, he said he did, is that right?
correct.
And this is a judgment showing that he had a tax lien filed in the amount of $6,535.01, is that correct?
Correct.
Mr. Reed, if you'll, I don't know if you have other exhibits, but we're going to have an overlap. So if you'll make that one 101, and then just, you can add, kind of go up from there. So that, all the question was in relation to exhibit 101.
Yes, Judge.
Are you offering 101?
I am.
Any objection?
Yes, Your Honor. I object to relevance and foundation, and it is hearsay.
May I, Judge?
What's the relevance?
Well, it's in rebuttal. That's to impeach the testimony of the petitioner. He stated under oath that he paid his taxes, never not paid his taxes. I'd like the court to consider this and consider the veracity and the weight of his testimony.
Objection sustained. 101 is not admitted.
Did you have an occasion to pull up in front of petitioner's office with 2 dogs in your car?
My church is on Bridge Street,
That's not my question.
and I was driving from church.
Did you have an occasion to pull up and stop in front of his office while petitioner was out in front of his office?
I stopped at the stop sign. I did not even know he was out there until my dog started barking.
Okay, so you heard petitioner's testimony that there is a stop sign 20 yards down the way from his business. Is that accurate?
I don't think it's that. I don't know the mileage, or I mean the distance. It's not that far, though, to be honest.
You admit to stopping your vehicle at a stop sign and he was right there outside your vehicle, correct?
I only noticed him when my dogs were barking, but yes, I stopped at the stop sign.
And what did you do?
I laughed.
Okay, did you roll the windows down?
The windows were already down. I have both German Shepherds with their heads out the windows. We drive around. It's what a lot of dog people do.
And do you ever follow him around Smithville at all?
No.
And where do you go to church?
Prevail Church, 300 South Bridge Street.
How far is that from the petitioner's place of business?
I 200 feet or so.
And so, on that, do you recall that date that the petitioner was talking about with the dogs in your car?
I believe it was like on a Friday, maybe. I can't remember actually what.
Were you going to church?
Oh, I go to prayer group a lot there. I go on Wednesday nights, and I also drive around town just to see what's going on because there's a lot of activity and developments going on. So a lot of us do that. Actually, there was a gentleman even named Jerry West that used to do that all the time too until he passed. But yeah, so it's just kind of a common thing.
You were taking photos or videoing him at a coffee shop or a grocery store. Did you do that?
No.
No further questions, John.
Cross-examine.
Your Honor. Bunch, do you like Eric Craig?
No.
You hate him?
No.
Do you think that he's bad for Smithville?
Yes.
Do you think he does things that are illegal?
Yes.
Do you think he is in cahoots with the local government?
Yes.
Do you think that he bribes the local government?
Quid pro quo happened this year. He gave close to, $20,000 or so with all of his businesses. And then shortly after that, he did get 3 parcels of city land. So there's an investigation on that. So I can't fully answer if he is, but it looks like it on paper to me.
Here, I'm going to move to strike that answer as non-responsive.
Sustained. Last part of the answer will be stricken as non-responsive.
Can you look at that notebook right there?
Sure.
Can you turn to Exhibit 3?
Yes.
Did you write this?
Yes.
And where did you write this?
On my election page, elect Kristine Bunch, Ward 1 Alderman, and then it looks like I also reshared it on my personal page into Smithville Women in Business page.
And are all these Facebook pages?
Yes.
And do you reference Eric Craig in this exhibit?
Yes.
Your Honor, move the admission of Exhibit 3.
Objection foundation, Your Honor.
3's already admitted, I believe. I think 3 is the one that came in. So 3's admitted.
What is the point you're making in this post about Mr. Craig?
So it's not just about him. There are other people listed in this page here. If you see Kelly Kablinski, she's a current alderman. Jennifer Lang Justice, she is also a real estate agent. So he's not the only one targeted. I do look at public documents with what these real estate agents and developers are doing in our small town.
And I appreciate that commentary. This can go a lot faster if you answer the question that I asked you, and I'm going to move to strike your answer as non-responsive.
Answer will be stricken.
So my question to you, Ms. Bunch, is what point were you making about Eric Craig in this post?
So if we read it, Eric Craig combined in working publicly together. So watch the TIF videos and ask Clay County Assessor's Office. So I was specifically mentioning his name and to reference the videos that I have been taking and then ask Clay County Assessor's Office.
When you say the videos that you have been taking, what do you mean?
Watch TIF videos. So the protest, I videotaped when we were protesting out there, what we were peacefully protesting for.
When did you make the post that is?
I have no idea. I would say it's been in the last 2 years. The TIF was going on about 2 years ago, I guess.
So you turn to Exhibit 4. Did you write Exhibit 4?
Did I write this is financing, quote unquote, letter of intent?
Yes.
Yes.
And did you post it on your Elect Kristine Bunch for Ward 1 Alderman Facebook page?
Yes.
And do you remember when you did that?
During probably the TIF, whenever it was going through funding with the city, I would imagine, or sometime around there.
Okay. And what's this? There's a photo down here of Your Honor, move to the admission of Exhibit 4.
Foundation, Judge.
4's admitted.
There's a photograph of a letter at the bottom. Did you take that photo?
I took the photo out of a public document from the TIF packet that was presented to the city of Smithville.
And that's a photo of a financing letter from the bank?
Appears so.
Did you ever call Eric Craig about any of these issues?
No.
Did you ever call Pulse Development?
Yes.
Did you know that Eric Craig was part of Pulse Development?
No.
You didn't know that those two were related?
The only 3 people that I thought were with Pulse Development was CAD Management LLC, Carlos, Andrew, and Drew. I did not know Eric was attached to them.
Did you find out?
Later, yes, but not if you're referencing this, I didn't know that at this time.
Okay.
Later I did.
So the fact that in your testimony is in Exhibit 4, the fact that Eric Craig's name is one sentence from Pulse Development, that's a coincidence.
I have no idea who he's involved with. He's involved with a lot. So if you're asking me if I knew at that time he was involved with Pulse Development, absolutely not. I thought it was just those three.
And so what I am asking you is, how come then in this post you use Eric Craig's name in one sentence and then the next sentence is about Pulse Development?
Because during the TIF proposal, he listed himself as a member of the 110 Smithville LLC. So I thought that CAD Management LLC was funding the project, and then this letter from Bank Midwest or whatever looked like a pre-approval letter. So, I mean, I thought one was the finance side and then one was the member side. I was learning as I was going, so I really didn't know they were all connected, but clearly they are.
Can you turn one page in Exhibit 4? You see the gray box on the bottom of that page?
Yes,
Did you write that?
yes.
In 3 places in this post, you use the phrase, "in my opinion," all in capitals. Why did you do that?
I have a lot of haters online that come at me and say a whole bunch of stuff, and so I always like to preface "in my opinion" because of using my First Amendment right, and I believe I'm allowed to have my First Amendment right, in my opinion.
Do you believe that using the preface, "in my opinion," protects you from liability for defamation?
No.
When in this post you use the terms developers and accommodators, did you believe Eric Craig was either of those?
There's a lot of developers in Smithville, so those can be referenced to actually another developer. There is somebody that uses the name as accommodator on his Missouri Secretary of State filings. So that has nothing to do with him that I know of yet. He may be involved in that. I don't really know.
Okay, I'm going to move to strike that answer is not responsive.
Sustain.
Here's my question. Listen closely. You use the terms developers and accommodators in this post. When you wrote that, did you believe that Eric Craig fit into one of those categories?
Judge, I don't object.
I
just asked and answered it already. I know you struck her response, but initially I think
Well, I struck the answer so she can answer. Overruled.
Are you asking how I felt and knew the public information at this time, or are you asking today, do I think he's involved?
I'm asking you, when you wrote those words, accommodators and developers in quotation marks.
Accommodators was another gentleman.
Hang on one second. Let me finish the question. That'll be a lot
Okay.
easier. When you wrote that, were you referring in any way to Eric Craig? Did you think he was in one of those groups?
Yes.
Okay, go ahead and turn to Exhibit 5. Did you write Exhibit 5?
Yes.
Did you post it to the Facebook page you operate?
Yes.
And is it a post about Pulse Development and the conversations you had with their attorneys?
This is a conversation that I had with Pulse Development. Yes.
You're going to move the admission of Exhibit 5.
no objection.
5's admitted.
Did you turn to Exhibit 6? Did you receive this letter?
Yes.
What was your reaction to this letter?
Honestly, I gave you guys a compliment. I said thank you because you said in here something that I thought was kind of an olive branch. You said that you appreciated the freedom of expression. So honestly, I even posted online that I was glad that somebody else could see that it's okay to speak publicly and have a freedom of expression. So I really kind of thought it was kind of a nice letter. I didn't think it was that vulgar, cease and desist that everybody's talking about, I guess. I thought it was kind of like, hey, we appreciate your freedom of expression, but just clarify that Gilmore and Bell does not represent Eric Craig. And I went on my social media and said, for the record, Gilmore and Bell does not represent Eric Craig. So I now understood it was your law firm.
Yes, turn to Exhibit 7. Is Exhibit 7 the reaction that you were just referring to?
Yes,
And did you write this post?
yes,
And did you take a photo, this photo at the bottom?
yes,
Is that a photo of the letter you received?
yes.
Your Honor, move the admission of Exhibit 7.
No objection.
7's admitted.
And your testimony a moment ago was that your response was to then go on social media and make the correction that Mr. Craig is not represented by Gilmore Bell. Is that right?
Yes,
Okay. And that was important to you because your understanding was that Gilmore and Bell was representing the city of Smithville.
yes,
And you're concerned about a conflict of interest.
absolutely.
So if we look at Exhibit 7, you see here at the start of the second paragraph, the sentence that starts, however. See that?
Yes,
So it reads, however, well, you wrote, however, if Eric Craig is not represented, in quotation marks, by Gilmore Bell, then why is attorney Megan Miller of Gilmore Bell speaking on behalf of Eric Craig, answering legal questions on behalf of Eric Craig, and saying publicly in the TIF meeting that, in fact, Eric Craig is paying Gilmore Bell's attorney's fees?
it was a question, yes.
Yeah, I see that. And is it's your testimony that this was the way in which you were clearing up the representation issue and admitting to the people who read your post that Gilmore and Bell doesn't represent Eric Craig?
Yes,
Objection, Judge Collins.
Sustained. Relevance.
Let's turn to, well, in the response to Exhibit 6, the first letter you received. See that?
yes.
Apart from making the post, the social media post we see in Exhibit 7, did you alter your conduct in any other way in response to that letter?
Objection, relevance, Judge.
Overruled. You can answer.
Did I say the question again? Did I
Did
what?
you alter your conduct in any other way?
No.
Turn to Exhibit 8. Well, and I apologize. I moved for the admission of Exhibit 7.
7's already admitted.
No. I believe 6 is already admitted. Is that accurate?
Yes.
Turn to Exhibit 8.
Okay.
Is this a letter that you received?
Now, I do not remember receiving this letter, but obviously there's a certified letter, so yeah. I mean, but I really don't remember receiving it, to be honest, but it's fine. I'll receive it right now.
Well, turn to the second page of Exhibit 8. You see the image of the green
Yeah.
certified mail receipt?
Yeah, so I must have signed it. I mean, I kind of started ignoring you guys. Sorry. I just did.
Is that your signature?
Yes, it is.
Okay. Your Honor, I move the admission of Exhibit 8.
I think 8's already admitted. 8's admitted. It's previously admitted over the objection. Still admitted.
Thank you, Your Honor. What was your reaction to Exhibit 8?
Well, my reaction is that you're related to him because you have the last name Craig, or somebody in your law firm was at one point in time. So I do believe that's a conflict of interest, even if you guys sold at some point. I really don't know. I'm not a lawyer, but that's that. If you're asking me what my reaction was, that's what it was. So it was starting to become a form of harassment.
Okay. Was your reaction to this letter to alter your conduct in any way?
I tell the truth and nothing but the truth, so help me God, so no.
Turn to Exhibit 9. You testified earlier that you opened and operated the Smithville News
Yes.
social media site.
Correct.
And where does that appear? Is it a standalone website, or does it appear on another platform?
Just Facebook.
It's a Facebook page.
Yes.
Did you write Exhibit 9?
Yes.
Did you write it about Eric Craig?
I think I was answering Debbie Doss. So it wasn't about him. It's just saying that I didn't deserve this harassing text message he sent to me on a Friday night or whatever day it was before his festival that I couldn't attend. I mean, he's texting me. So I was just saying it was not to him. I was just telling Debbie Doss that I just did not feel that it was warranted, that I've never attended any of events. I don't drink. It's not my crowd. So I wasn't even planning on going.
You want to move to the admission of Exhibit 9?
Any objection?
No, well, foundation, relevance, Judge, those are my objections.
9's admitted over the objection.
Mr. Craig testified to having sent you a text message asking you not to come on to various properties that he owned. Did you receive that message?
Say the question when, or what text do you refer? He's texted me several times.
Okay. When do you remember Mr. Craig texting you?
That was that couple days before his festival.
And was that message asking you not to appear and come onto his properties?
Yes, and I have a copy of it if you need it.
And what was your reaction to that message?
I laughed with a laughing emoji.
You sent that back to Mr. Craig?
With a laughing emoji, yes.
Did you laugh IRL, or did you just send back that message?
It was a little laughing
I
emoji.
understand. What I'm asking you is when you got the message, you as a person, you physically laughed.
Yes, I have to laugh.
Why?
Because this is so much abuse towards me. You don't understand. I'm a survivor of domestic violence and rape. So this is very eerily familiar. Having abuse of power and control and trying to tell me what to do. And I'm not doing anything to harass him. So this is my First Amendment right to speak publicly of what's going on in our small town, the illegal operations that are going on. So yeah, it's at this point a little comical sometimes. Sometimes you have to laugh instead of cry.
And in fact, did you characterize Mr. Craig's message to you as abusive?
Absolutely, this is abusive. This should never be happening.
Okay. And if you'll turn the page on Exhibit 9, did you then post this power and control wheel, which is a reference to a pattern of conduct by domestic abusers?
Absolutely.
And was the point you were making that, in your view, Mr. Craig fits into that pattern?
Yes, he is abusing me.
And what do you think is a justified response to abuse?
A justified response. First, you go to the police. You make a police report. So that's a justified response because you feel fearful or something bad has happened. So that's step one: is you go to the police and you file a report.
Have you ever done that with Mr. Craig?
No.
In your view, is the victim of domestic abuse justified in using violence to respond to her abuser?
What are you seriously asking me right now?
Objection, argumentative, and
Sustained.
Turn to Exhibit 10. Did you author this post?
Yes.
And was this post a video?
Maybe a reel or on my story. My dogs.
Sorry?
My dogs.
Okay, this was a video you took
Yeah.
of your dogs?
Of my dog, yeah.
What were they doing in the video?
Playing ball, and I caught his teeth, and I thought it was cute.
Your Honor, I move the admission of Exhibit 10.
Any objection?
objection, foundation, Judge, and relevance.
Sustained as to relevance.
Did you post this after the incident in which you saw Mr. Craig outside of his office when you were in the car with your dogs?
I don't remember when I posted it. I post pictures of my dogs all the time. So I don't know what day I posted that. Sorry.
You don't know whether it was before or after?
I really don't.
Overruled. You can answer.
I really don't. I post pictures of my dogs all the time. I own a pet grooming shop, so I'm always playing with dogs. So I've got lots of videos.
Did you ever make a post that, with reference to Mr. Craig, that your dogs can tell good people from bad people?
Probably, because they can.
And is it your perception that your dogs believe Eric Craig's a bad person?
I believe that there's a lot of bad people in the world. I don't know what my dogs believe. That sounds ridiculous.
Well, you've just testified they can tell the difference between good people.
Well, they can. They can sense. They can sense when somebody's like anxious, or they can sense, if they're fearful of somebody. The German Shepherds, they're working dogs. That's what they're supposed to do.
And did you convey to the public that your dogs had that sense when they encountered Mr. Craig outside his office that day?
I do not believe that all coincided around the same time. But yes, I love my dogs. They protect me.
Could you and if you felt you were threatened, would you use your dogs to protect yourself?
Are you seriously asking me?
I'm going to object. Calls for speculation. I don't know how she could possibly know what she would do at any particular time. I don't know how she could speculate what her dogs would do or what she would do. So.
Response, how's this relevant?
Well, Your Honor, she just testified that she loves her dogs protect her. And she's also testified that she believes Mr. Craig is abusing her. And so then to bring her dogs in proximity with Mr. Craig is indicative to think that she can use 2 German Shepherds to protect herself, quote unquote, from Mr. Craig, which could put him in fear of physical harm.
Overruled. You can answer briefly.
Sir, I'm a survivor of domestic violence and rape. I would never hurt somebody intentionally. I would never sick my dogs on Eric Craig. I don't care about Eric Craig. I would never have my dogs used as a weapon. You want to know why? Because my dogs would die. And then if my dogs died, then who would be my companion? I use service dogs and emotional support animals because I am a survivor of domestic violence. I would never sick my dogs. So for the record, you can just be assured that nothing's going to happen with my dogs going anywhere but just with me. And I do ride around with them in my car. It is not to hurt anybody, harm anybody, or make you feel upset. You have no idea what it's like to be a survivor of rape. And I've sat in these courtrooms to try to get protective orders. I know what domestic violence protective orders are for, and this is an abuse of the court system, and Eric Craig is doing it to me. What would he think if his daughters got accused by a developer? Reverse the story here. You have no idea who I am. You're going to learn, though, I'm a survivor of rape. I'm a survivor of domestic violence, and I have service dogs that I love dearly, and they love me. So if we're riding around in a car and somebody like Eric Craig, who doesn't like me and they can sense it, barked at them, I'm sorry. It wasn't intentional. I promise you that. I couldn't even have planned it for him to walk out of his shop the exact same time that I walked by. So how dare you question me and abuse me and use your political power? I just don't understand it. Are we this corrupt in America right now?
Ma'am, your answer's done. Next question.
Your Honor, I'm going to move to strike the end of the answer is not responsive.
I'll strike the end part of it about as far as her personal experience will be stricken. Next question.
Turn to Exhibit 11.
God dang.
Did you author Exhibit 11?
Do I what?
Did you author Exhibit 11?
Did I write Exhibit 11? What?
Exhibit 11 is a social media post.
There's nothing in this binder. So I don't know what you're...
You may.
Oh, boy.
Did you author Exhibit 11?
Yes.
And when you make reference, did you author this in response to receiving word of the ex parte order of protection?
So this was the first ex parte order Judge Cheryl Roberts did. Once she recused herself, you guys extended this order. So then with the extension of the order, I couldn't go to the Christmas parade that my church was having. I couldn't go to my board meeting, the Historical Society. They were meeting downtown. I couldn't go to my women's group. We have stuff that goes on, and that's where I get a lot of my help. I couldn't go to any of that stuff. So I said, can you imagine missing the Christmas parade, missing board meetings, missing events downtown, missing prayer groups, missing much more because a boy got his panties in a bunch. Yes, I wrote that, and that's how I feel. I'm like, this is like childhood play.
Your Honor, move the admission Exhibit 11.
No objection.
11's admitted.
The boy you're referring to got his panties on a bunch. That's Mr. Craig.
There's a lot of boys in town, not just Eric Craig. He's included, yes, but there's a lot.
Did anyone else cause you to miss the events listed in this post?
Well, Chief Lockridge, who's supposed to be here, I subpoenaed him. He was one that actually told Eric Craig to file this ex parte in the first place. So he obviously has something against me because I filed rape in Smithville. So they're not even looking at my rape report. So I think Chief Lockridge has something against me. So yes, I would include Chief in that as well.
When you wrote this post, and you're referring to a boy, at that time you're referring to Eric Craig,
Yes,
Eric Craig and other people,
yes,
Overrule.
or other people entirely?
all the above.
Can you tell me, when you wrote this and you wrote a boy, can you tell me everyone who you meant?
Well, it looks like I just said a boy and not boys. So that would be Eric Craig, a boy.
In the second part of this post, you write, "Good thing we have some honest judges, not all, but some, in Clay County courts. And if I can figure out which ones are and will actually uphold the laws, I'm going to defend myself in court with everything I have." Do you see that?
Yes,
Have you figured out if our judge here today is one of the honest ones?
Objection, Your Honor.
I'd love to hear the answer, but I'm going to sustain it.
No further questions, Your Honor.
Redirect.
No redirect.
All right, you can step down, ma'am. Thank you. Anything further from respondent?
Just closing, Judge.
All right, respondent rests. Petitioner, argument?
Thank you, Your Honor. Your Honor, if we walk through the applicable statute, we'll see it, and compare it to the evidence, we'll see that the evidence has met or exceeded every statutory requirement. And we'd start with 455.020.1, which states that any person who has been the victim of, among other things, stalking, may seek relief under sections 455.010 to 455.085 by and filing a verified petition alleging such stalking by the responder. Now, we've done that. And what 455.020 establishes is stalking alone is enough to justify an order of protection. So what is stalking? It's defined in the statute. That's 455.010.15. Stalking is when any person purposely engages in an unwanted course of conduct that causes alarm to another person when it is reasonable in that person's situation to have been alarmed by the conduct. So here we have a course of conduct. Now we can get the statutory definition of that term. It's found at 455.010.15b, that a course of conduct is two or more acts that serve no legitimate purpose, including but not limited to acts in which the stalker directly, indirectly, or through a third party follows, monitors, observes, surveils, threatens, or communicates to a person by any action, method, or device. So we have a course of conduct here because we have evidence of multiple times of surveillance, multiple events of surveillance according to Mr. Craig. And at least one of those acts of surveillance is something that Ms. Bunch has admitted to. We also have multiple acts of communication. Now remember that communication can be by any method. So it doesn't have to be just calling the house at 2 a.m. And in this modern era, it's rarely that. That often in modern era, stalking takes place through the advent of social media. And that's what we're finding here, where there's lots of events of Ms. Bunch assailing Mr. Craig through social media, attacking comparing him to a domestic abuser, attacking his business, accusing him of tax violations or bribery or being a conflict of interest. All of those things are threats we've seen here. And then there's the interaction with the dogs. So we have two or more acts. We don't have legitimate purposes, and those acts constitute threats, but also merely surveillance, observation, and monitoring can be a course of conduct. Going back then to point 1.5, we see that the other situation the other term is that Mr. Craig has to be alarmed, and that alarm has to be reasonable in his situation. And admittedly, in the early stages, while uncomfortable, the sort of protesting or political criticism by itself may not rise to the level of stalking. But it does create the context that makes Mr. Craig's alarm reasonable in his situation. That is not something that happened out of the blue. It is not something that exists in isolation. This is not a stranger pulling up outside of his business who happens to be coming back from church and having some dogs bark. That's not what's happening. We're having a multi-year attack on Mr. Craig in various forms, and it's getting worse. And we just need to stop it before it gets much worse than it's already become. Now, the conduct has to have alarmed him. Now, the statute defines alarm, 455.010.15.a, alarm to cause fear of danger of physical harm. And you heard Mr. Craig testify that by the time he had undergone the online criticism and accusations, and then gone through the surveillance and the monitoring and the photographs, culminating then this interaction with the dogs, which were then posted about, as a joke, that those things together put him in danger of physical harm. And a order of protection is not only something that exists for exes or people in domestic violence, and it is certainly a critical tool for those survivors, but it is not limited to that by statute. And this is an appropriate use of the statute where we've seen a course of intentional conduct over an extended period of time. We've met all the statutory definitions, and all we're asking is to be left alone. We're not here today, despite the statutory right to do so, asking for attorney's fees or court costs or any sort of other remedy, than to be left alone. And if we can succeed in receiving that remedy, everyone can go about their business. That's all we're asking, and it's a minor restraint on Ms. Bunch, and it's certainly one that we've qualified for under the statute based on the admitted evidence here today.
All right, thank you. Respondent.
Thank you, Judge. My client wants to be left alone too, Your Honor. I do agree that the statement of 455.010, but the alarm has both a subjective and an objective component, Judge, meaning that one person must subjectively fear the danger of physical harm, and a reasonable person in the situation would likewise fear the danger of physical harm. And again, Judge, I'm citing a newly handed down case from the Eastern District. It's ED 11-21-41. It's ALO v. GLN. And within that, Judge, the court in the Eastern District cited LMM and also stated where the petitioner does not present sufficient evidence that they fear physical harm or that a reasonable person would fear physical harm, an order of protection is not appropriate. In the ALO case, Judge, the court found that at the hearing, the appellant sent her threatening text messages and told her he knows and will make sure she's not safe. In that case, the respondent testified appellant called her around 15 to 20 times a day, but they didn't produce any text messages. In saying that there was no order of protection required in that case, Judge, they also cited several other cases. But lastly, more importantly, in the dicta, the court wrote, respondent's testimony relating to appellant's threat to post photos of her undressed on social media does not satisfy the objective component of the statute. While the court is sympathetic to respondent's concerns of intimate photos of her being leaked on social media, appellant threatening to post the photos is insufficient to demonstrate stalking because the act is intended to prevent potential violence, not hurt feelings or harm to reputation. And this threat would not cause a reasonable person in respondent's position to have feared physical harm. And they also cited the LMM case, which stands for the proposition that disparaging social media posts are insufficient to prove stalking, as it would not have caused a reasonable person fear of physical alarm. With respect to the dogs barking at the petitioner, Judge, it was clear that my client was smiling. It sounds like it was a chance encounter. It certainly wasn't. She didn't say anything. He testified that she laughed. If there's an order of protection that needs to be granted, maybe it should be against the dogs for the dogs making him feel like he's in fear of physical harm. Frankly, if I had two German Shepherds barking at me that I wouldn't know, I'd be afraid of them myself. But considering the context of the entire case, Judge, and the testimony that's been presented today, I don't believe that an order of protection being entered in this case is something that the legislature intended when they enacted this law, Judge. So for those reasons, we're requesting the court deny the relief requested by the petitioner and request that the court dismiss the pleadings for failing to make their case.
All right. Thank you. For the decisions issued, just will note what I show that we have admitted as far as petitioner's exhibits. We have 1, 3, 4, 5, 6, 7, 8, 9, 11, 12, 13. So that means 2 and 10 have been removed from the binder that will go as part of the court's record. I don't have any exhibits that came in from respondent. I believe that's accurate. The one that was offered was, the objection was sustained. That being the case, it sure seems like we're all on the same page with this case falls under the definition of stalking under the Adult Abuse Act. The parties don't have a relationship. They don't have a domestic or intimate relationship. And I think both counsel have accurately stated what the law is. Certainly Respondent's counsel referencing the ALO case, which the court is familiar with that case, and does find some of the holdings in that case persuasive. And as stated by Mr. Reed, I think, and so we're all on the same page. Stalking occurs when any person purposely engages in unwanted course of conduct that causes the alarm to another person, to cause fear of danger of physical harm. 2 or more acts serve no legitimate purpose, which a stalker is indirectly, and that's where we talk about the surveils, which was noted. Both counsel understand the ballpark that we're in right now. Petitioner himself testified that prior to the dog incident, if we want to call it that, there was no fear or no alarm, no fear of physical harm. The only fear of physical harm came from this dog incident. So if we narrow it down to that, we have to have the subjective and the objective findings. While the court may find persuasive the petitioner's testimony being subjectively in fear of responding, the court does not find that the objective component has been met on that incident. Additionally, the Court of Appeals advises us trial court judges to exercise great care in making sure that sufficient credible evidence exists to support all elements of the statute, that the stalking provision is not intended to be a solution for minor arguments. Additionally, as cited, the court will take judicial notice of the ALO versus GLN case. As noted by Mr. Reed, that where petitioners not present sufficient evidence they fear physical harm or that a reasonable person would fear physical harm, an order of protection is not appropriate. And I'll speak to you directly, sir. I understand this is not something you like. You don't want this out there. I get it. This is not a desirable situation for you. But this court is bound by the law and bound by what the Court of Appeals directs us to do. And at this point, the court will find that you failed to meet your burden under stalking. And therefore, the court will deny the order of protection. Now, as part of my dicta, I can also tell respondents, certainly there's no order that's going to be entered against you because the petitioner's failed to meet his burden. That does not mean that you should continue doing what you'd been doing. You have an attorney who's very capable, and he may very well advise you to leave this gentleman alone because I think we all knew what the law was, or at least now you know what the law is. And if this comes back again, there may be a different decision. You're certainly entitled to your constitutional rights. But as far as coming around the petitioner, any sort of veiled threats, any of that, I would strongly encourage you to leave the petitioner alone. You've stated you want the petitioner to leave you alone. I'm sure that he's willing to do that. But at this point, the court will deny the petition. No attorney's fees will be ordered. Costs will be waived. There's no cost assessed. And I hope that with the spirit of holidays coming up, that we can all just get along and leave each other alone. The court will make a judgment in favor of respondent. You all are free to go. Good luck to you all.
Thank you.